thank you so much for being here. We were planning on working through the Oregon legislative session and talking about the law changes that impact landlord-tenant law, as well as those that have been experiencing homelessness. There were some law changes there too. So we'll be talking through each of those. I am happy to have you all, if you don't mind, just putting things in the chat. All three of us, Terry, Angela, and myself, will be watching that as we go through. And so then we can talk through questions as well. And there'll be breaks too throughout the presentation to talk through questions as we kind of broke it apart for everyone. So without further ado, let's get jumping right into it. As I mentioned before, myself and my fabulous coworkers, Angela and Terry, have worked really hard on this presentation to track the laws, especially Angela. And so we've been making it through here. I do want to make sure that you all know we are not lawyers. Nope, we know a lot about landlord-tenant law, but we are not lawyers ourselves. But we're also not cats, just a heads up there. We tracked 30 or 73 bills. Of those, 48 of them died, and 25 of them passed. So that process. The major bills that we'll be talking about today is we're going to talk about a lot related to the COVID moratorium. So the extension of grace periods, as well as that 60-day or 90-day safe harbor that you might have heard about. There are some changes to occupancy laws. We also did some changes to the screening process, which is a huge one, and I can't wait to share that with you. There's a cleanup of the bill from 2019, which was SB 608 when it came to exemptions for affordable housing. So we'll talk through what that looks like now. There's also some fair housing trainings that are requirements for those in the realtor field or.
Caitlin, I'm jumping in.
Yes.
We can hear you, but
Yeah.
you're glitching. Like your face is glitching, but your voice isn't glitching.
Okay. Unfortunately, I think I'm gonna have to do my camera off this entire time, so I'm so sorry,
too.
y'all, but it's gonna be better for everyone.
Sorry.
That's okay. Thank you. All right. Well, I'm glad that you can at least hear me. We'll also be talking about ID replacements, as well as lead-based paint enforcement. One of my favorites that goes with the rent guarantee program and Rentwell. There are some technical fixes to those programs and a whole bunch of honorable mentions. So first and foremost, I thought it would be best for us to talk about where the eviction moratorium stands right now. And in the process of the last 3 days when we were putting these slides together, man, it has changed a bunch. So first it was like, bye, bye, bye. We don't have an eviction moratorium anymore. Oh, but wait, it's back again-ish. So let me go through this with you. So we are back to having the federal moratorium. This is very specific on where individuals live and if there's an increase or surge of COVID cases in that area. It's very specifically tied to counties. What this does is it bans individuals from moving forward with evictions for non-payment or no cause related evictions. This CDC moratorium has been in place in some way, shape, or form, more or less, since last September. And this last version of it just kicked in yesterday, day before. It's been a little bit of a blur. And it will go all the way until till October 3rd. And like I said, it's very specific on where individuals are living and if there is a rise of COVID cases in that area. Some individuals on the most pro-tenant side will say that this stops a landlord entirely from doing any part of an eviction related to no cause or non-payment. And I've heard all the way up to no, landlords can still serve that paperwork. They just can't actually move to the very end result of having sheriffs come and lock a person out. So they could possibly go through the whole court case and they just can't do that one last step, but the person would have an eviction already on their background and it would just be waiting out. So this is ideally not what we want folks to get into. It's really postponing evictions rather than preventing them. So when they're looking at places that have an increase or a surge in COVID, currently what we're looking at is all of Oregon except for Lake County and all of Washington. So between the two states, there's only one county that this federal moratorium wouldn't qualify for. And if during this time between now and October 3rd, any of those counties actually decrease in their rates of COVID and have that decreased amount for 14 days, then they would actually jump into the ability to start giving out eviction notices, and vice versa is true. So let's say Lake County did see a surge and it brought them up, then even though people might be able to give evictions today, if it surges again tomorrow, they wouldn't be able to move forward on those evictions. So this is going to be very time sensitive through this process. And there's the link there too, so you can check on the counties. To quickly go through it, I like to spend some time talking about the federal moratorium. However, the protections that Oregon has already put in place prior to the federal moratorium has always been stronger for our tenants. So we tend to look at our state and what our state is doing rather than the federal moratorium. But protections are protections. So I wanted to make sure that you all had that info. When it comes to federal protections, each household member that is over the age of 18 needs to qualify and send a letter of declaration to their landlord saying that they qualify under these 5 different stipulations for allowing them to have the protection of this eviction moratorium. So those being that they have to obtain rental assistance, they are low income or limited income. They do not currently have the ability to pay rent, and that is because of loss of income, loss of hours, or extraordinary medical costs. That during this time, they've at least tried to make partial payments at best, and if they were evicted, it would result in them being homeless or having to double up, which would increase possible spread of COVID and make this unsafe for most folks. So that's where the CDC was really focused on, is that safety piece and stopping the spread of COVID. Some other guidance about this too is that they really wanted to make sure that if somebody has signed a previous declaration, the federal declaration form, and given that to their landlord, they don't have to give another declaration form to their landlord as long as they have that one on file. Now, the federal is different than the state declaration of financial hardship. So we want to make sure that they've got the federal one on file. A landlord cannot attempt to evict them during this time. If they have COVID or have possibly been in contact with somebody with COVID, they can't move forward and say, for the safety of everybody else in this building, I'm asking you to leave because you have COVID or you've possibly been exposed. The only way that a landlord could potentially do that is if that tenant who has COVID or has been exposed is going around and truly making the rest of the community unsafe, coughing on their neighbors, coughing on door handles, things of that nature. So the tenants do not have to sign the official declaration form from the federal declaration form. So if they don't have the ability to print it out, it is fine for them to re-handwrite it as long as it says all the exact same things. And then they can take a photo of that and send it to their landlord. That qualifies as well. However, remember, I'm going to say this a bunch of times. Federal declaration form is not the same as the Oregon declaration form. And we will get you links to the federal one as well. Tenants can use the declaration form translated in the language that they're most comfortable with. So currently, I believe it's just in English and Spanish, but if they want to take the time to have it translated into the language that they're most comfortable with, then they can send that to their landlord and it works just the same. And every adult household member does have to submit this declaration, but not every one of them has to turn it into their landlord. One individual of that household can get all of the forms at once and turn them all in one grouping. It doesn't have to be each individual communicating that directly with the landlord. It is important to know that during this time, even if somebody is covered with the protection of the federal eviction moratorium, they can still get charged late fees during this time. And once again, if I didn't say it loud and proud, I'm gonna say it again. Danger Will Robinson, this form is not the same as the Oregon declaration form. Whew. And there's the link for you. Angela, you had double checked and verified that that worked. You had a current working link, and I'm not, I think that one's the same, but if not, we'll get you the working one.
I don't know if that one's the same, but I know I double checked it today and we'll send it out
Yep.
in the follow-up
Okay.
email, along with
Cool.
the other applications for Oregon as well.
Yep. You will get so many things between the slides here, as well as all those forms and so much more. So if there are questions that we don't get to answer during this time, we'll wrap around and make sure that we get them in the email too. And we are recording this as well, and so you'll get a copy of the recording too. I imagine that people have a whole bunch of questions from that, but I'm actually going to move through the other Oregon moratorium pieces so we can kind of group all of them together and then we can talk about all three of these. So we've got 2 more bills left. I want to spend some time talking about the grace period extension. So this is something that had been more or less in place during this time. There were many different iterations of it. And what this primarily does is one of the things is if anybody receives a notice for non-payment of rent, those notices prior to had been 144-hour notices or what we most commonly knew as 72-hour notices. Those have now had long extensions put on them. So they're either 13-day notices or 10-day notices. So it gives people an additional amount of time to file the paperwork that they need, to get the money they need, to kind of get those resources set up. And this is going to be true. It's a temporary fix, so this isn't a forever. This will be the case that these notices will remain that longer time up until the end of February 2022. And then they'll revert back to those hourly notices. The other thing it does is it talks about money. So what that means is any rent that was owed, any rent, debts, fees, whatever it may be to a landlord between April 1st, 2020, all the way to June 30th, 2021. No tenants need any declaration forms. Any of that back rent, that back owed amount is now due by the end of February 2022. Nobody needs to sign any declarations for this. Everybody is in this bucket. They do have to pay that by the end of February. It's not forgiven, but they have to pay it by then. if somebody does make current payments and maybe they pay a little bit more than what their current rent is, because come July, rent was due July 1 for July. So they have to maintain their current rent payments minus this little eviction moratorium that we just got into with the federal government. Woo. But if they do make payments that are over that, a landlord needs to make sure that the way that they're using these funds is that it's for current rent owed first, and then it's utility charges, and then they can look at late rent, and then lastly, any other fees or documents or charges that they might have. So it always has to go in that order whenever there's that overpayment. If somebody did have a non-renewal notice during this time, they were coming towards the end of their lease, and the landlord went, I just am not interested in renting to you. And they would have naturally said this prior to the COVID moratorium. What would happen in that situation is usually the lease would end. However, we've frozen those leases in place right now, and they actually have until the end of August to move. So whatever their lease looked like during that time, they will continue with that same lease up until the end of August. They still have to move out. There's no right to remedy there, but it at least gave them some additional time. Landlords can deduct past rent too in these situations. So anybody who did have that notice of non-renewal, their lease was coming to the end, if they had a security deposit, then the landlord could deduct any past owed rent from that security deposit. Except for in Portland. Portland has a lot of but Portlands. So in Portland, they can't do that because of the fair ordinance. There was also an extension to the grace period. There are some really exciting things that came out of this too that will have long-lasting effects. So for landlords who are possibly looking at new tenants, somebody is moving out of their space and moving into another, those potential future landlords cannot look at any evictions between April 1st, 2020 to February 28th, 2022. Doesn't matter. It doesn't matter if it was for non-payment, which they shouldn't have been giving during this time. It doesn't matter if it was for tenant conduct. None of it matters. No evictions during this entire time. They can't take it into consideration. If somebody has had an eviction during this time, even though landlords are not supposed to be taking it into account, we know that it's still going to be on their background report. If they can showcase that they've paid all the fees that are related to that eviction, they can get those eviction records sealed so they can have those expunged from their records so it acts like it never happened. Other things that can happen is that landlords are not allowed to report any rent-related debt or any debt to landlords to credit bureaus during this time for any of that debt between April 1st, 2020, all the way up until June 30th, 2021. They also can't tell future landlords about any debts that was owed to them. But they can still tell screening companies, which then can still tell future landlords, which is a problem. However, a double but here is that future landlords cannot take into consideration any of those non-payments or debts related to past landlords. So even if they get that information from a screening company, they have to pretend like they never saw it and move forward with this. And that is between now and January 2nd, 2028. Yes, I said that right. That is not a mistake. January 2028. And then the last thing it does is it allows landlords to impose occupancy standards. So landlords at this time have been able to kind of impose their own occupancy standards. This could be stricter to local laws. It could be possibly even stricter than some safety concerns, and that is not at all the case anymore. So with this law, between now and the end of February, landlords cannot impose these restrictions. They cannot charge anybody or terminate fees based on guests staying within the unit. So the idea that people may be doubling up because of COVID or the wildfires, this cannot be an issue that causes somebody to get an eviction or a fine. However, if a guest is staying longer than 15 days in a 12-month period, then the landlord can require that that guest be screened for just rental history and criminal history. It's not any income base. This person isn't paying income or paying rent. What this is looking at is this person safe enough to live in the unit? So, and safe enough to be on the property or around other tenants. If somebody is approved from that, then they can have them sign a temporary guest or temporary occupancy agreement. And those occupancy agreements cannot end before the end of February. They could be longer than that, but they can't be shorter. The guest still has to follow the lease agreement and follow the rules. And if they don't, they can be asked to leave. They do not have the same rights as tenants. It's not an eviction process here. They just straight up get asked to leave. They don't have any rights to try and go through the court process here. Whew. Lastly, if a landlord violates any of this, they're liable for up to 3 months of rent plus any actual damages. So that is the first of 2 different Oregon laws that we have surrounding this. And with that, we need to talk about, okay, but what happens when it comes to July? And I am gonna switch it on over. So take it away, Angela.
Hi. This is my first time addressing this group in this capacity, so give me a little grace. And I also want to give a shout out to our youngest housing advocate, Jacob, only 1 year old and on this call and learning all the things. So thank you for being here. So now I start with, but July. Oh, do I have control? Oh no, you do. Oh yeah.
I do.
And then she flies through. Don't fear. My favorite bill, SB 278, is here.
Mm-hmm.
Oh, there she is. So this is our what we're calling the 60-day safe harbor law,
Mm-hmm.
which basically means if a tenant applies for rent assistance and provides documentation to their landlord, that tenant cannot be evicted from the time that they provide the documentation. The key point is when you provide the documentation. That documentation can be in several different forms. They made it super easy for us. So it can be email, text, certified letter, any of those things can count as proof. Something that does not count as rent assistance is family or friends, but it can be a church group, it can be an agency. It doesn't have to be, the ORAP money. It can be from other sources. It just can't be friends and family. And the goal of that being is, as we all know, in our industry we work in, it's been severely underfunded, and all of a sudden they really need us to work, and the money's being bottlenecked. So this bill is designed to help give folks who need assistance, have applied for assistance, the time to get said assistance given to them. And instead of but Portland, it's but Multnomah County, which makes me really happy because I'm a lifelong resident. Multnomah County decided to step it up and make that 60-day safe harbor zone a 90-day safe harbor zone. So just to spice it up for us all, we're giving folks a little bit extra time in Multnomah County. Same so the declaration applies. That link up there is the basic link to the ORAP money. We'll send all this to you as well as the paper form to apply. 211 is also a super great resource. and shouldn't have as long as wait times as maybe they've had in the past because they have had an increase of funding. The ORAP money is $500 million, and it can be used for current rent, past utilities, and also can be included for 3 months future rent. So you might be fine now, but you may need help in the future. Payments go directly to landlords or the utility companies, utility providers, and it's the money is based on need, and the most vulnerable people will be funded first. That doesn't mean that we're deciding who that population is. We are just trying to get the money out as quickly as possible, but in some sort of order. I'm saying we, like I'm divvying out money. And the best thing that you can tell tenants that are in need to do is to gather their documents, apply for assistance yesterday, today, tomorrow. Keep applying, apply everywhere, and check back often. And don't wait till the last minute. You may be at eviction court and say, hey, I'm going to give this a go. That there's a little bit more turnaround time for that. So we're really encouraging folks to apply as soon as possible. But note that the time doesn't start until the proof of purchase is shown to the landlord. Questions.
So I think one of the first questions that came up for me is, it sounds like there is documentation if somebody goes to apply for the ORAP. Do we know what type of documentation that they might need to supply in order to make sure that they have fully done that entire application?
I don't know if I'm tracking that question quite because I'm not seeing it. Sorry.
Oh, sorry. That was my own personal question that I wanted to share with you. Sorry.
I can try and answer that, Caitlin. Can you hear me okay?
Yeah.
So I'm currently working full-time in the ALETA system, which is the Oregon Emergency Rental Assistance Program out of Clackamas County. So yes, there is a certification letter is what it's called. Once you've submitted your complete application, that is emailed to the applicant. And then as far as documentation that's required, so proof of ID, proof of a lease. We often end up asking the landlord for a ledger, and then proof of utility bills. Those are the basics. It's obviously a lot more complicated once you get into a case, but
right.
Those are the basics.
Thank you. Yeah, and I imagine that income documents would also be right.
Yeah.
Thank you. Thanks for jumping in. All right. Let's go back to our questions.
I'm gonna go to the very top and ask Matthew's question about, does the ruling of the Supreme Court, the ruling being 5-4, affect I'm assuming the CDC eviction moratorium? I am not tracking anything at the Supreme Court level, so I don't know if anyone else.
I know that there was some major concern when there was talk about this becoming another extension to the moratorium, and there being some major concerns that this might possibly be impacted by a ruling of the Supreme Court. I had not had a chance to check in on that prior to this training, but I will do that and I will follow up with any information. But I know that there was some major concern that it didn't feel like the Biden administration had the ability to move forward with this moratorium.
I think Matthew might have an addendum to the question if you want to go ahead.
It's not really an addendum. Can you hear me, ma'am?
Yes.
Yeah.
It's not really an addendum. It's more or less, it actually came out in the news It said that President Biden was attempting to extend the moratorium. He was unsuccessful because of the ruling of the Supreme Court, with the Supreme Court voting in a 5-4 decision and throwing it down. And so I don't know. It's you probably look in the news, you know, President Biden ended moratorium or where the case is, Supreme Court 5-4 decision. I'm just not really sure how that affects what it is we're talking about right now.
So how that would possibly affect us is all of those things that I just said about the federal moratorium, not necessarily the state bills. State bills will still stand. Both of those that we spoke about, whether it's the 60-day extensions or 90-day extensions, as well as the repayment grace period. It doesn't matter, federal government, those ones stand. However, everything I said about the eviction moratorium up until October 3rd, that might have just been easily wiped out of the books with the court ruling. So it's
Yeah.
been moving rather fast.
And so the next addendum I would have
Mhm.
would be how does the state overrule the federal government when I mean the federal government can't be trumped. So
So they're different things doing similar things, is the best weird way that I could put that. So yes, these are all what the Biden administration put through in the CDC with the eviction moratorium helps in similar ways to what the state is doing, but that is really preventing any actual evictions where the state is saying, no, you still owe your rent currently, but any
Right.
back rent from that time, you get an extension on that. And that way the federal ruling is really specific to what the federal ordinance was or the federal law was, where this is another nuance that helps in similar ways, but not exact same. Same with a 60-day extension too. So thank you.
Yes, ma'am. Thank you, ma'am.
It was a little difficult for me to wrap my head around as well. And one thing that was helpful to me is the state of Oregon is not issuing any eviction moratoriums any longer. What the state of Oregon is doing is allowing folks time to get the rent assistance. So a landlord can still serve eviction papers. The eviction process will stop as soon as you show your proof of purchase.
And if after 60 days comes and goes, there still isn't that funding in the hand of the landlord, they can still move forward with the eviction as it is. So wherever it stopped in that process, a person can, you know, on the first day that rent is owed, if they don't have the money, they can supply that paperwork then. They may not supply it all the way up until the day that they're actually walking into court for the first hearing. That's kind of their window of trying to get this paperwork in. Obviously, we want people to try and be as supported as possible and get it in sooner rather than later. So, good questions. Yes.
We had another question. Does this apply to income-based apartment complexes?
I believe that popped up when we were talking about the occupancy standards there. And my understanding is that there was no exemptions written into this when it came to specific federal housing or affordable housing. So my reading of that is any housing within Oregon needs to follow this guidance.
Okay, we've got a thumbs up from the asker, so I think we're good. And yes,
Yeah.
Addison, the ORAP application can take a long time. So we're really encouraging people to apply as soon as they can. It's also why Multnomah County, who has at least, I think the last number I looked at was 10,000 cases of applications of people that have qualified but haven't received the money. Yeah, our county has thousands. Yeah. So it's a backlog. It's a total backlog situation, and we really just want people to apply.
And the last time that I was hearing numbers here, about 60% of individuals were starting the process of applying, but we're not actually finishing in order to get that letter. So we really want to make sure that people get all the way through the process. It does sound like there is some support at the state level that they're contacting people who were halfway through and saved and never came back to try and get them some type of letter and work with them through that assistance. But we can't assume that just because they start the application that they get that letter of approval that they can show their landlord. So we really need to make sure that they can walk all the way through it. One thing that is available is on Friday, there will be another training from the state of Oregon about how to take somebody through the process of applying. I will send out that details later today, as well as I have a recording from their previous one last week. So I'll send that to you too.
That's all the questions I have from the chat.
Oh, there's one more.
Except one just popped up. Two
Go for it,
popped up.
Tay.
Does low income still apply if not COVID related?
I'm wondering when that came in. It's low income. I'm assuming that it was very specific to what I was saying in that moment, and now it's questionable that I don't know what it's attached to. I apologize. Feel free to put.
Was about
Yeah.
eviction moratorium for the federal level. It was required that you it's COVID based.
Yes. So somebody has to be lower limited income there, and it was pretty specific, if this is indeed still the case of the federal moratorium, that it is based on how much an individual made on their last year's taxes and put on that, or if they are receiving any kind of federal benefits, then they would be qualified in that marker. Okay. Any others?
Yes. Lauren is looking for a little bit more clarification on something we said earlier about multiple sources of assistance.
Yeah.
Yeah, we encourage everyone to apply everywhere they possibly can. The short version.
And the important thing to know. Yeah.
Can I ask a follow-up question just to make sure I'm really getting it? I'm sorry, I just like lots of clarification. So not just so like doubling up for the same months, because I know when I did the OERAP or the ORAP application, it does ask you if you're like if you have already like requested or received assistance for those months. So I just wanted to like, you know, I have somebody who did apply and I'm not sure if he'll get it because he's not on like the higher needs end, but he still does need assistance. Would it be okay then to request like assistance for those same months for that same person? Does that make sense?
Yes. I think from a different provider is absolutely fine.
Okay.
So what would happen is then they would wrap around and go, okay, did you really receive that funds? But the important part is that when they get that 60-day notice, even if they got it from applying online with the ORAP funds, if they end up getting funds from their church and that's how they're going to pay that rent, it's a 60-day window. And regardless of if those funds come from the place that they had applied originally, it doesn't matter. So it gives them extra time to look at many different options to get that paid.
Okay, thank you.
Yeah, thank you.
And then Addison had a follow-up to the follow-up. I'm just gonna read it. Will the backlogged applications be reviewed in the 90-day grace period, or will the grace period potentially be extended? Also, fun celebration. Her folks have all gotten their letters. So yeah.
Woohoo! I think what the state has been clear on and how because surprisingly, this 60, 90-day grace period, the 61 in particular with the state, it was a lot of hard work, both from tenant advocates and landlord advocates, to come together and say, here's what we need to be most successful. And so I don't imagine that in goodwill and good conscience that there could be an extension on that grace period time, because there was some really particular expectations of the landlord side as well as the tenant side to make this agreement and pass this bill.
It was absolutely fascinating to watch because I've never been in this type of environment except on TV. And it like actually happens. It was like I was watching legislation happen. So we also did say the CDC was probably not going to extend. So
Mm-hmm.
everything really is moment by
Mm-hmm.
moment.
Mm-hmm. Yep. And also that 60-day bill was possibly one of the fastest bills to ever be passed in Oregon legislation, or in like the last known landlord-tenant laws that we can think back on. It was very, very quick. Whew, okay. I think that we move forward. The
Yeah.
largest amount of the information that we've provided today is actually what you just got. So if you're like, oh my goodness, we only made it through 3 right now. Oh, I promise we will move much quicker now. So I wanted to spend some time talking about occupancy law and some changes that have happened here. This is not going to be the same as the occupancy changes that we just spoke about in the previous bill, but it does have some larger implications, and that's why I wanted to spend some time talking about it. So the changes here were really based on the idea that there are some local governments or local regions that have created housing barriers for folks when it was related to the number of people living in the same unit, especially if those individuals were not connected by blood, by marriage, legal adoption, or guardianship. So there were some places across the state that said if you have more than X number of people living together and they don't have any of these connections, they can't stay living together. Regardless if the landlord was fine with it, it was the city ordinances there. So the purpose of this bill was to really think about what this enforcement looks like and why we have it and why the local governments are a part of this. It really prevented the idea for individuals who were not related from doubling or tripling up in housing to be safe. And so with the passage of this bill, they have now banned any local ordinances from being put in place in the future related to this, or any previous laws being actually utilized, or anybody using them against any tenants out there. So it pretty much just wiped any of the previous laws off the books related to this. It will go into effect January 1st, 2022. And like I said, this is not the same type of occupancy laws as the ones that I was just previously talking about. So in these situations, landlords can still make their own occupancy standards for their rental unit. They just cannot base it on the family status of the family. And that was true too when you think about fair housing. So now it's just a requirement that the local ordinances also follow those fair housing laws too. Any questions about that one? Okay. See, much faster. All right, here's a really exciting one. I'm going to hand it over.
SB 291 changes the screening process at a state level. People that live in Multnomah County or Portland may be familiar with some of these, but this is for the whole state now. One thing that it does, it clarifies what a screening cost can be. It's a combination of two things: the actual cost of the screen from whatever screening company the landlord uses, and then average administration cost for it. So how much does it take you to push the buttons, essentially? 291 also does it's such weird not pushing the own button. The 291 also specifies what has to be in the information packet at the time that they are requesting that screening fee. Those things are whether or not they require renter's insurance, and if so, how much renter's insurance. Fun little light bulb there. If you are under 50% AMI, as an applicant, you are not required to have renter's insurance. It also must include the cost of the actual screening, what the landlord screening criteria is, so the process that the landlord uses, who they use, are they using credit reports, criminal reports, that sort of thing. They have to walk you through all of the things that they look at. In that screening packet, they also have to include the tenant's right to dispute or appeal a denial. Just kidding. I can't read it. I'm so sorry. I didn't
Oh,
print this one out.
that's okay.
I'm going to read it. The applicant's right to dispute the information provided by a screening company on the credit reporting agency. So if something comes up on their screen that's wrong, they have a right to appeal it.
Especially when it's related to credit, because there's the federal protections around credit. So it doesn't matter if the landlord says, I don't appeal applications, if they're denying because of credit, this individual gets to see what the denial was about and possibly try and dispute it.
Why don't you go for it? Because you can see it better than me.
Okay, no, I'm fine. Okay, so new ones. So all of those that we just discussed have already been written into state law. Like, surprise, they've already been there. If a landlord is accepting a fee, a screening fee, they have to have all of these written out. Newer things, though, is the right to appeal a denial if there is the right, if a landlord allows for that appeal. And we'll talk a little bit more about that, because there's some that landlords can choose whether or not they allow for a denial or an appeal of a denial. And then there's others that they can't now. The other thing that they have to state in writing now is a notice of non-discrimination required by federal, state, or local laws, plus non-discrimination policies of the landlord. So this would be simple fair housing law. This was already what they were following, but they need to put it in writing now. And then previously stated in there also was they need to say how much that the rent is going to be and the deposit that they're requiring. However, they can put in a clause written in there saying that it is subject to change. If they don't have that clause in there, it's really hard to think that they have any right to change that from the moment that the person is applying for the rental. So look at those things in detail. What we're going to spend a lot of time in detail about is this appeal and denial process. This is big. It is where Oregon meets Portland law. So take it away.
So one thing that we really liked about this is that it does put an actual timeline on a denial letter being sent, or reasons for the denial being sent. Okay. Senate Bill 291. If a landlord denies an application, they now have 14 days within that denial to give the reasons why they denied to the applicant. The reasoning for the denial must include the names and address of the screening company that they used, any explanation of why any supplemental evidence did not still get them approval afterwards, and the right of the applicant to appeal the determination if any right to appeal exists. I'm super jazzed about this law, and I cannot believe I'm fumbling through it this much. The big caveat is if there is a denial based on criminal history. Even if a landlord doesn't allow an appeal process after a denial, they do have to give an individual assessment of an applicant if they are denying them based on criminal history. That individual assessment has to take into account the nature and severity of the incidents, the number and type of incidences, the time that's happened since the incident occurred. Was I 18 and I'm 39 now? And lastly, the age of the applicant. So was I young when it happened? And it's also been a lot of time. That helps a lot of folks that a lot of us work with. Criminal history can be a huge barrier. It also goes hand in hand to what we teach in Rentwell, which is like get your evidence ready, have it all organized, and be able to submit it to your landlord. We've also got the little discotheque Portland Fair housing going down in the corner. So it's exciting that the state followed what Portland has done.
Mm-hmm.
This goes effective January 1st, 2022. If the landlord fails to comply with not doing an individual assessment because of criminal history denial, they can be charged up to $100. Questions?
So I think that this is a really big step for the state. This is something that Portland had already done with the fair ordinances. Fair goes a little bit further than what's happening at the state level, but this is a huge step for the rest of the state to look at. And it's important to know that individuals, if they are denied, so it doesn't set a precedence on how quickly a landlord has to review an application. But do remember, they can't be accepting other people if they're just still waiting with this denial in the wings. So if they have decided to deny somebody, they have within 14 days to write an essay on why that person was denied. Even if there's not an appeal process for that, then that potential tenant has a whole list of what they would have needed to overcome any screening barriers. And they can go to another future landlord and go, hey, look at me. I got all of these documents in a row, rent to me, right? So they can really utilize that information moving forward with other places. Any other questions on this one? It's a lot to process.
Caitlin,
Yeah,
I
yeah.
have a question.
Uh-huh.
So I've had a veteran I've worked with be given a denial letter recently, and wondering about if someone does choose to appeal that.
Mm-hmm.
A lot of times landlords can just jump right into screening the next applicant right after that denial letter is sent, right? And so does that make it, are you still able to appeal it if the landlord's saying, oh, sorry, we've already began screening the next person?
If they have an appeal policy, they can still say that they don't accept appeals except for in the credit and criminal history come January. But if they have an appeal process, even though they've denied somebody, they've written that document within 14 days of that denial, sent it out. The moment that they send that, they can start looking at the next tenant in line for this. But it still gives the other individual who got denied the opportunity to appeal. And if they appeal, maybe they don't get that exact unit, but they should be put on the list for the next available unit.
Okay.
Does that make sense?
Yeah, it does. Thanks.
Yeah.
I took a landlord training on this as well. And one thing that they are trying to encourage landlords to do is accept all the supplemental information or evidence that an applicant may have at the top. So if you know that things may pop up, you can give it that all to them at once. That might help, just make things go faster.
Mm-hmm.
We also have another question in the chat. What are reasons why landlords would not allow appeals, and for what reasons can they deny the right to appeal?
I can start off with this one. I was almost about to ask you the same, so so the reasons why a landlord can choose not to accept appeals is if they are a small mom and pop landlord who don't have the time or the ability to be looking at all of these review documents for each individual, and they just have one property that they're trying to rent and keep the mortgage on, it's okay for them to say, sorry, I don't do appeals. They still have to write that essay about why they denied somebody, but they can choose to do that. However, if somebody was denied because of credit history, they have a right to review their credit report. And if there were any errors on that, they can appeal that with the landlord. And then come January, if a person was being denied because of the criminal history, regardless whether a person has a I don't do appeals, they would have to look at that appeal process. And so, and as far as like the right to appeal, some really important appeals that we see all the time is a lot of the times people are getting denied for things that are related to a reasonable accommodation. For example, if they have a eviction in their background, but it turns out that that was related to a domestic violence relationship that they were in and they were fleeing that unit. What the landlord might see is just an eviction with a whole bunch of property debt associated to it and not necessarily know that that was related to a domestic violence situation. And therefore, because of that relation to the domestic violence, a landlord can't deny anybody because they're a survivor of domestic violence. So those are always good appeals to really think about how this connects to any of those protected classes. Good questions. All right, I'm going to keep moving forward. So one of the things that happened was a technical fix this year. It was a pretty simple technical fix, but a very important one. So in 2019, we passed huge legislation known as the Tenant Protections, or SB 608, Senate Bill 608, which provided limits to rent increases, as well as limiting no-cause eviction notices. There was an exemption when it came to the rent stability portion of this law that said, hey, if somebody has affordable housing, then they already have to jump through so many hoops to have affordable housing and make sure that their tenants are supported through this process, that we don't want to add additional penalties on them or additional duplicate documentation that they need. So if somebody has affordable housing, then they are exempt from this 7% plus inflation because they should already be doing it. Well, that worked for some, but not all. I think that there were some clear case studies that happened where individuals were moving into the property and skyrocketing the rent. And so even though it was affordable housing, because of those moving in, suddenly the tenant's portion of rent was unaffordable. So they went back and they said, all right, we're not going to say affordable housing. We're going to clean up that language so that that's clear. So now it's if a dwelling is regulated or certified as affordable housing by federal, state, or local government, and there is no increase to the tenant's portion of rent, then for those places in particular, they are exempt from this 7% plus inflation. So that was the cleaning up piece. That's all that one did. Important, but small. Another very important one that I like a lot is that fair housing trainings are now going to be mandated for individuals that are either actively getting or renewing their real estate license. So for that license, they need to complete 30 years of continuing ed training every 2 years. And that could be in any topics that they chose previously. And now at least 3 hours of that time needs to be spent on a fair housing specifically. So it's a call out on what that is. It is effective now. So individuals can move forward if they are in the process of getting this recertification or starting it. They can start doing their fair housing trainings and have that count. It will be fully enforced by a year from July 1. Whew. Okay, small but important. I mean, one day maybe we just have trainings for all landlords. I don't know, who knows? Anyways, Angela.
This was my favorite bill. I know I keep saying that, but this sounds complicated, but is fairly straightforward. So House Bill 3026, the DMV will waive the fee for an ID card for those experiencing homelessness. they will give a new card or 2 replacement cards within the 2 years, as long as the person experiencing homelessness has been, they call it a certification of homelessness. They have to get from a qualifying agency, so a place like Transition Projects. That form will let them, it is awesome, Lauren, it really is. That form will allow them to go to the DMV to get that free identification card. And it is currently law, but they're working on the administrative part of it. So the DMV is working with agencies to get the language together. But what will happen is you get a form, go to the DMV, get an ID. The real IDs is something that is not mentioned in the bill, but is mentioned in the administrative part of it. And what we think is going to sort out is when the real IDs become mandatory, that yes, they will be covered under this fee waiver through Bill 3026. I know anyone that has written checks for the DMV will be excited, so they won't have to do that anymore. That's it for that one.
And it's really important to know that this is for IDs. It's not driver's licenses. It's just IDs. Any questions about that one?
Oh, we've got Matthew.
Yes. Is there any dates for implementation for that bill, or for that?
I think, yeah. So I think that they're really looking for January 2022 is when they're trying to implement that. We know that the government can move a little slow every now and then, but they had already reached out to providers to get some insight about what that process may look like from nonprofits. So they're moving along at a good clip.
Thank you.
Yep.
And we have a question from Lauren. What about transitional housing? Do you mean if they are a certified agency to prove the certification of homelessness? I'm thinking.
Ooh. I want to make sure that that is related to this topic. Oh, yep, go for it.
Oh no, I was gonna say the same thing. I want to make sure I'm understanding the question.
But I would imagine that if somebody is in transitional housing, depending on how long the housing is for and how long they can stay, I think it would possibly get a little harder to argue that this person is homeless, depending on what that stay at that transitional housing space looks like. If it is a really specific shelter site, or if they are in treatment and they're only there for 90 days and there's nowhere else to go from there, this makes sense. But I would say that long term, or like 2 years, or supportive permanent housing is not going to be the places that could possibly give this documentation. Perfect. Okay. There's some lead-based paint enforcement that came up. The effective timeline for this is actually next month. What this gives is actually more teeth to the Oregon Health Authority on the oversight of if there are lead-based paint hazards that are reported to them. They have more ability to go after violators for them to clean up their properties. They have the ability to bring in third-party abatement or assessments for those risks. And they also have the ability to impose fees and fines for folks too. So we know that there are properties that have lead-based paint in them, especially if they're older than 1978. And this gives the ability that if we've got tenants that are living in those older homes and are starting to get really concerned about their health, that the Oregon Health Authority can step in and work with them and their landlords to do this. There are programs, especially here in Portland, that will come in and do free abatements for landlords too, depending on their income. So there are opportunities out there. The other one that I'm really excited to tell you about is our landlord incentive technical fix bill. And we actually had 2 bills going at one point because we tried to get this done last year. It's a very small fix, but very important. And last year it was looking golden, and then everybody walked out of the Capitol, and then it was just done. So this year we doubled down, and we had 2 different bills. This one passed pretty quickly, and then we got to reutilize the other bill, and that one became that 60-day safe harbor. So that was a gut and stuff bill. What this does is it's twofold, both for voucher holders and for graduates of tenant education programs. So what it does for those who are voucher holders is it requires all Oregon housing authorities to participate in the landlord guarantee fund that is paired with the housing vouchers. So if somebody has a Section 8 voucher, a housing choice voucher, they live a place, they can live there for several years. And if they leave and there's any damages, past due rent, evictions, the landlord can go to the Oregon Housing Authority and pay up to $5,000 beyond their security deposit for that individual. They don't have to take any tenant education programs for that. So it now requires that across the state, as well as one of the scary things that was happening here is if somebody did want to utilize any funds out of this guarantee on somebody who had a housing choice voucher, in order to do that, they had to file an eviction first with the court. So it would immediately put that barrier on that tenant. So we've removed that exemption from this so that it doesn't have to create another barrier in that tenant's ability to get housed the next time around. And then on the flip side for Rentwell, and tenant education programs, we did some technical fixes to the rent guarantee. So similar program, just shared with tenant education. There was a really specific lifetime limit for landlords on this. So we can have graduates of the program go to landlords and say, hey, if you're willing to rent to me, and in the first year, if I leave, there's any damages past due rent, the program will pay up to $5,000 beyond my security deposit. Really cool. However, if they had a graduate who they needed to utilize all that $5,000 on previous to this amendment, then that means that that landlord was stuck at their lifetime limit. And even if they rented to a Rentwell graduate in the future, they wouldn't be able to access funding. So it was really limiting our ability to work with landlords and really partner with them. So we removed that, and now it's per tenancy. The other removal is there was a weird exemption and technicality in there that was written if somebody owed PAC due rent, even if it was $3,000 and that was under that $5,000 limit, we could only pay $2,000 of it. So we removed that entirely. And this will be effective January 1st, 2022, but the state is already utilizing. They assumed that this was going to pass, and so we've been moving forward with it as is anyways. Any questions about those 2 exciting ones? I know I'm usually the most excited about those rent guarantee programs. You should be too.
There isn't anything in the chat. And
Okay.
I did say I wasn't going to brag on you, but
No, don't do it.
I
Let's
am
just, yep,
very
look,
proud of you.
here
And
is a new bill.
She did good. Okay, so we expanded this from our last presentation because there's a lot of questions about it. House Bill 3115, it helps folks that are experiencing homelessness. It requires cities and local governments to relax any laws that they have about folks that are sitting, lying, sleeping, or trying to keep warm outdoors on public property. So really it's just an opportunity to try to give people a chance to exist, essentially. If someone, especially someone experiencing homelessness, feels that they have been in violation of this law, they can go to court and say, this wasn't fair. And if for some reason the court doesn't rule on their behalf, the person who got violated's behalf, those fees don't follow that person in the future. So it's a chance to give people a little bit of power. It's effective immediately, and it aligns us more with the federal laws that recently passed. I think it was US versus Boise. So this
Yeah.
is something, okay, that's being done on a federal level that our state is really just getting a jump on. It has a companion bill, which is rights for camping sites. This one's a little bit more nuanced, and I know it's going to hit a bit of a nerve, especially if you're in Portland. There's been some camp raids recently. It is currently in effect as of now. It was an emergency bill that was passed. What the camping sites rights bill does is it takes the notification that a sweep is going to happen from 24 hours to 72 hours. Those notifications have to be posted at all entrances of the campsites. On those notices, it also must include where personal property will be stored and how that personal property can be obtained. The law itself also writes in the administrative laws of how to keep property stored in a orderly manner. The bill also allows local laws to adopt greater protections for their individuals experiencing homelessness if it chooses. So if a city or county wants to go above and beyond this, they certainly can.
And then the last one that I will touch on is there was a shelter siting accelerator. In this, it defined what an emergency shelter is into law. So it's nice for us to finally get that definition carved out. As well, it requires local governments to allow the siting of emergency shelters by qualified individuals or qualified agencies. That as long as the law or the land use laws and regulations would allow for a shelter to be sited there, they can move forward with accelerating that process in order to get those shelter sites there to allow more people to find stable housing. It also wrote into it that there was previously a 3-vehicle limitation on motor vehicles that were parking in religious properties or on religious properties or sites, and now it expands that as well so that they can be able to help more individuals in staying safe. This really comes out of also thinking about things such as neighborhood associations that might feel a certain way about a shelter coming into their area. This would allow acceleration beyond that so that neighborhood associations can't just prevent people from finding housing because they may not want that in their neighborhood. And this is already in effect too. So the League of Oregon Cities played a strong role in getting this and moving it forward. There's been a lot of support on this. And it's really important that it's not just anybody can, on their property, set up some tents and go, hey, this is a safe place, but it's got to be really an agency that has a focus towards housing individuals and helping to support them in their process. Whew, okay, any questions about those 3 bills? And
Nothing in the chat. I'm surprised. I thought there'd be some more feelings about some of these.
oh,
Maybe they're stuck on moratoriums and safe harbors. And
yeah, that really heavy stuff that we put at the front end, right?
Yeah.
At the end of a day. Well, if there's nothing more here, what I'll do is I just want to go through some honorable mentions with you. These are mostly bills that had funding related to them. So these were bills that allowed for either tax exemptions, maybe they had funding really specific to youth. Some of them were very location based as well. So we were tracking all of those too. There was substantial amount of money given to provide housing and supports for those working towards housing in our state this year. It was historic how much money went towards housing. So that is good. All right, that is the end of the presentation. I told you, I know that we were really, really heavy on the front end, and that was super concerning, and that it would go really quick and we would get out of here much earlier than expected. So thank you all so much for being here. If you have questions, please feel free to stay on with us. But if you don't, feel free to drop off and you'll see an email go into your inbox with all these details. Thank you all so much for being here.